Ebusianfo aha Ghanatube so ensema koso oh my god aha na onsabeka nyina the trending one, the latest one, the hot one any nya eka kan lebusianfo matena se say die ene na nsem no mababo we bia no pa say yenti ebusianfo be so say baka kotie ensem no na ye ba na me matoa so amount.
Coming up, the Ghana Bar Association stands against the suspension of the Chief Justice, Geto Tukono, demanding the immediate revocation of the said suspension amongst other demands. We're going to be getting into the full complement of the Ghana Bar Association's demands and some reactions to it. And in fact, if you've been following the news, you'll get to know that this is not the first time that the GBA, at least for the last 3 days, there was this suspicion of whether or not what we were reading on social media especially was indeed true, because there hadn't at the time until now been any official statement of communication from the Ghana Bar Association after their bar conference over the weekend that they had indeed issued this particular statement and resolved based on their communique after this bar conference that they were against the suspension of the Chief Justice as in accordance with Article 24610A of the 1992 Constitution. Now, but so exactly what are they saying? What are they asking for? Now that there's an official statement from the Ghana Bar Association after their bar conference confirming what we have been reading all the while, calling on the president to, as a matter of urgency, release what constituted his decision that led to the establishment of a cause, or as we say, a prima facie case against the Chief Justice, Geto Tukono, resulting in her subsequent suspension. The association's call to the president is part of resolutions, in fact, that they made at their just-ended mid-year conference over the weekend. My colleague Dennis Babari-Wadam, who is a private legal practitioner in good standing. Essentially, you're a member of the GBA, is it not?
I'm a member of the GBA.
Okay, let's get in. But you were not at a bar conference.
No.
I know you were attending to other matters.
No, I was in the outfit
of media general concern. But let's get into the statement. What exactly are they asking for?
Well, so this is now official because over the weekend there had been some conversation about the GBA having passed a resolution of some sort and making demands. But I think at the time over the weekend, the one topical thing that was up there was the fact that the GBA was demanding the revocation of the suspension of the Chief Justice. Now it is clear that indeed on the said day, which was on Saturday, April 26, the GBA indeed passed a resolution, amongst other things, demanding the suspension of the Chief Justice. And clearly, the argument that the GBA is making, or how they arrived at the conclusion, is to the fact that, I mean, in their view, the decision to suspend the Chief Justice, it's discretionary, and the president in performing such a discretionary function ought to comply with Article 296 of the 1992 Constitution, which provides a guide as to how discretionary powers should be exercised. It is the view of the GBA that the president, who is not a judicial officer, is not a judge, ought to have published some instrument of a sort, either constitutional instrument or a statutory instrument, specifying how that discretion was exercised. And to the extent that that did not happen before the suspension of the Chief Justice, the GBA is of the view that the said act was unconstitutional, and they didn't mince words in saying that. They described the act
that the suspension of the Chief Justice was unconstitutional.
Yes, as being unconstitutional.
I see, and on what basis did they describe that as unconstitutional? Because
in their view,
we here on Ghana Tonight with you on the magic wall have gone through the Article 29610A.
Yes,
that specifically stipulates exactly what the president has done, is it not?
Yes, they don't dispute that. And Alfred, even if you recall, on Thursday, which was on the 26th of April, 2 days after they had issued, they passed this resolution, the GBA issued a statement, and in that statement, they made mention of how they were following the process and how they were aware of the processes that were outlined in Article 146. They did indicate that they were only calling on all persons who were in this process to heed to Article 296. So they themselves expressly mentioned that they were aware of the process under Article 146, 6, 7, 8, 9, and 10, which includes the suspension, of course. But they were only cautioning that care should be taken that full compliance be given to Article 296. So in hindsight, if you look at that statement, then you can understand how this resolution came about, because the reason for declaring the conduct of the president, and I say declaration because that's what it appears to be, that it is unconstitutional, is because in their view it does not conform with Article 296, which guides the way discretionary powers should be exercised according to the Constitution. To that extent, according to the GBA, they deem that as being unconstitutional. Now, having said so, they're also demanding that there should be an enactment of clear regulations to guide Article 146 proceedings on removal of justices. Now, Alfred, even though they did not say more, knowing what we know and how we got here, and knowing that there are pending suits at the Supreme Court regarding the removal of the Chief Justice and seeking interpretations, it is clear that indeed there has to be a clear path as to how to navigate Article 146. A typical example would be the question of whether or not, if the president receives petitions for the removal of the Chief Justice, the first thing the president has to do is to forward the petitions to the Chief Justice and get her response before the consultation with the Council of State, or the process can be ongoing before the president now gets the response of the affected Chief Justice.
I see.
That is a question that hopefully in the coming days the Supreme Court will answer. There's also the question of timelines. You recall that the Chief Justice, when she wrote the letter to the presidency asking for the petitions, she was asking for 7 days.
Yes.
The president gave her 10 days. The question is, how long should it take for one to respond to such petition? So, I mean, even though the GBA...
But in the absence of all of these regulations and the constitutional instruments that the GBA is asking for to guide the execution of Article 146, specific 10A, the president can only work with what is existing, is it not?
Precisely so.
So, has any wrong been committed?
Well, I do not see the GBA on that particular one to be faulting anyone or to be suggesting that a wrong has been done, except to say that it's a demand they are making.
Okay.
And possibly this can be taken into consideration amongst other things moving forward, if there's a need for a constitutional review perhaps, and if we begin to look at the reactions that are coming through from senior lawyers, maybe that will fit into that particular conversation. Alfred, it does not also end there. The GBA also wants the immediate release of the decision establishing the prima facie case against the Chief Justice. What they are in essence saying, that the president should show us how he, together with the Council of State, arrived at the decision that a case had been made against the Chief Justice for which she must answer. They are saying that it should be in line with established precedents. The GBA does not mention what the precedent is. But then again, if we follow discussions in the last few years and times that we have come to a place like this, we recall somewhere in December when Professor Koko Asare petitioned the president for the removal of the same Chief Justice. There was a statement from the presidency indicating how that petition was dismissed.
But that was after the fact, is it not?
That was. So yes, after the fact. So what it means is that at the end of it, a decision was made whether there was a case or not. That was communicated.
After the process had ended.
Of course, because there was no case made, the process had to come to an end.
Okay.
But that's a good point you're making. Because the arguments that are coming, and of course, there's the Supreme Court decisions to that effect as to when the proceedings can be made public. You know, when we work through the process, part of the process is that the whole proceeding must be in camera. So
yes,
that's the argument that others are making, that, I mean, if the process is supposed to be in camera, how then do you expect that the president will make such revelations at this point when the process is still in progress? There's also the last one, which the GBA is condemning political commentary, and they say that that undermines the judicial independence and then a pledge to protect the judiciary from such interferences. There will be an interesting reaction to this particular point, because somebody has taken issue with this. Because if the GBA is condemning political commentary because in their view it's prejudicial, then why then is the GBA already declaring what the president had done or has done as unconstitutional.
Let's seek an answer from the public relations officer of the Ghana Bar Association, lawyer Xavier Koji, is joining us on the telephone. Good evening, lawyer Xavier Koji. Thank you for joining us.
How are you, sir?
I'm well, thank you. Now, so why are you condemning political commentary? Let's start from there. But then again, in the same statement, you go ahead to express your opinion of the president's decision in accordance with the Constitution upon the advice of the Council of State as unconstitutional.
Thank you very much for the opportunity. I think what we meant by that is that, you know, there were allegations or statements that before the sitting president, as we have it now, became president on his campaign trail, he made certain comments that when he won when he became president, he would remove the chief justice. I think I've heard something like that. Then the other side to counter that, okay, now that he started a process, or they also come in the future, we'll do same. Those are the comments that we are referring to, that they are prejudicial, and we don't want to hear them from both sides. Probably before we didn't say it this way. That is what we meant.
But well, that's what I'm saying, that in this same statement that you raised this concern, you are also essentially making comments and expressing your opinion about the president's decision, which is consistent with the Constitution, as you have acknowledged that he's done nothing wrong. So why are you condemning something that you're condoning in this same statement?
What we mean, I believe you are referring to what we said, the president's suspension of the chief justice is unconstitutional.
It's unconstitutional, yes.
I believe that's what you are referring to.
Exactly so.
Let's put it in a context. The reason we put it that way is that yes, the president has every right to exercise his discretion to suspend the chief justice per the Constitution. But Article 296 also tells us how discretion should be exercised, to the extent that we sitting members who were at our conference were of the view that in this particular instance, relative to the suspension of the chief justice, the president ought to have caused a publication of regulations in the nature of constitutional instrument or statutory instrument before going ahead to exercise that discretion. So it's not as if we say that he has no right to trigger the process.
I see. But is it in your place as a Ghana Bar Association to declare the president's act in accordance with the Constitution as unconstitutional?
I think that we are not doing this in our capacity as a judicial authority. Many times you hear people say, oh, this is unlawful, this is unconstitutional. It doesn't mean that those people are they conjure themselves into court. Maybe the cost is coming from us as an association. That is why you haven't an understanding. There is no way that we can ever equate ourselves with the court of competent jurisdiction. We are just describing what has happened that is unconstitutional. That is our thinking. So should we even decide to pursue it further, maybe by going to court? I said maybe. That may be the grounds on which we'll be going. That does not mean that we have already decided to go.
But well, there are others who also hold the view that yes, this act is constitutional. What would be the GBA's position on that?
Can you take that again?
I'm saying that as you describe that decision as unconstitutional, others also hold a strong view that what the president has done is constitutional. What's the GBA's position on that?
That is the issue. If you put two lawyers together, I can tell you on one issue you have the same position. So that is the beauty of it.
So let me establish this.
At a meeting,
right?
At that meeting, we hold the view that by not publishing the regulations before suspending the chief justice, that conduct or exercise of that discretion was unconstitutional. So if there are others who hold a contrary view that look, irrespective of that, is constitutional, we will not fault them because that's their position.
But can you point to me?
Even at the GBA meeting, different views were expressed, except that just like it happens at any other meeting, whatever majority agree on, that is what carries the day.
But point to me exactly what the president has done that you describe as unconstitutional. Exactly what has he done?
I think that is what I've just said, that the failure to have caused regulations to be published relative to his exercising his discretion in suspending the Chief Justice.
But
that is why we say so.
But you agree that the regulations you talk about, in the absence of the regulations that you are expecting to be published, the president can only work with what is existing now, is it not, in the Constitution, correct?
Yes, the president has, you listen to me this way, the president has the right to suspend the Chief Justice. So he has that discretion to exercise. But we are saying that in exercising that discretion, he should have recourse to Article 296, which says that once he's not a judge or a judicial officer, he ought to have caused a regulation to be published in the nature of a CI or statutory instrument. That's what we're saying. So we are not saying that he cannot go ahead, but in go ahead, we expected him to have affected his mind to the provisions of Article 296, which required him to publish a regulation in the nature of a constitutional instrument or statutory instrument before exercising his power to...
So are you saying that the president should have disregarded what the provision of the Constitution is?
The president should have
disregarded what the provisions of the Constitution is, because as you acknowledge that yes, I'm coming to the point. You acknowledge that he acted based on the dictates of 14610A, but then again, yes, not recourse to 296, but specifically.
Yes. So which means that he had not fully completed the process before he started. Well, it should have concluded by having the published before. So we are not saying that he cannot exercise that discretion, but we're saying that in doing that, he ought to have affected his mind to 296, which required him to publish regulations.
But the dictates of 146 is pretty clear, is it not?
The dictates of what?
146 is pretty clear on exactly what the president has to do in this particular instance.
He may exercise discretion. Is that not it?
Absolutely. So why do you say the process? You say he started that. I'm coming to a point. You say he started the process, but he should have before. Is that mandatory in law?
No. Excuse me. Hello?
Yes, I can hear you.
Yes, the question again.
Yes, I was saying that you were saying that he started the process well, but then again, at the point of suspension, he should have averted his mind to 296. And I'm saying that is that consistent with the provisions of 146 specifically?
Why not? Because 146 says he may suspend the Chief Justice. The name makes it discretionary. So to the members sitting at that meeting on Saturday, they think that, or they held the view that that situates in the context of 296 relative to exercise of discretion. So he ought to have published or caused to be published regulations relative to the exercise of the discretion he is supposed to be exercised, or he has permission to, or he has the right to exercise under 146.
Enti semno ena yeti ebusuafo obetimi eja comment no de amame ewo comment section papa na meje bre akinkan de abusuafo nsan na mesori mo so no mekai obium se aha Ghanatube trending hot issues, latest issues, sad news, happy news ni kaka wona ebusuafo aha ena onsa ebenka ni na enti make sure yourself or best subscribe amame na afin so odo wonsa emia notification bell no so so ede amame send e be ya se ensem no me dituma na wenya no entem pass me ma owe fin so se obe like in videos no ede amame na me ametina se ede ensem no ebrem midin ene snowy sisi ade makram